Today we're going to be talking about industrial stormwater lawsuits, how to deal with them, how to understand what's going on and some of the root causes. We're going to look at some examples of some litigation around the country and specifically in California. I know we have a large California audience. Quick intro, I'm Ryan Janik. I'm one of the founders of Mapistry. I've spent about the past 12 years working largely on water issues, stormwater, both from an engineering perspective, and then over the past 3 or 4 years, integrating a lot of computer technology, software technology into the stormwater space, making sure their staff are trained, even dealing with these lawsuits that we're talking about today, working on fixing BMPs, reviewing SWIPs, making sure staff really know how to train properly. As you also joined by Nathan Metcalf. He's a partner at Hanson Bridgett in San Francisco. He's going to be talking more from the litigation legal perspective. I'm going to try to present on a more technical perspective today. What we do is we spend a lot of time on education. Education is kind of a core component of what Mapistry does in preventing these lawsuits, making sure people have a really robust stormwater program. We do a lot of these free webinars, but we also do online training. We do in-person workshops, both for staff and at the executive level. And then we incorporate all of this in an online platform. So making sure rain events don't get missed, inspections don't get missed, you close the loop on any deficiencies, et cetera. And then where education and software doesn't fill in, we do kind of boots on the ground, conventional consulting, engineering, everything from designing BMPs to doing exceedance reports, different tier level reports, depending on what state you're in. As I said, Nathan Metcalf is a partner at Hanson Bridgett. We've worked together on a number of litigation cases related to industrial stormwater, but he's got a ton of experience in this space, not only in stormwater, but also in water rights and other water issues. Going back to basics here, what is a citizen lawsuit? Under the Clean Water Act, there's a provision that allows a citizen that's been, that is in the water body, the receiving water body, that say a facility discharges to. They have standing and they can file a citizen lawsuit under the Clean Water Act against the facility with all sorts of allegations. And Nathan's going to go into it more, but it's typically filed by an environmental group on behalf of their constituents or their membership, alleging some sort of damages to the water body that they might use for swimming or fishing or recreation. And the intent of these was to fill a gap. There was an acknowledgement when the Clean Water Act came out that regulatory agencies couldn't enforce and couldn't do everything that was necessary under the permits. So they gave this provision to citizen groups or citizens, individuals, to file lawsuits to fill that gap around enforcement. So a couple reasons why this is important. I mean, there's a lot of legal requirements around permits. If you're in a lawsuit, it can have a big hit on a brand, and then there's huge financial implications. So paying attention to lawsuits, in terms of prevention and defense is not only a financial implication, which we'll talk about, but there's a big brand hit that can potentially happen because of this. Why do companies get sued or fined? And it comes down to a handful of things usually. Sampling data. If you have a history of always being over benchmarks, action levels consistently, that's a big red flag. It's one of the biggest drivers we see in companies getting sued. The other factor is really kind of shoddy site maps, no SWIP, inadequate SWIP. It's why we often get brought in at Mapistry to do like a quick review of a SWIP site map data, make some suggestions on how to improve the program, and then either the staff will implement themselves or we'll implement it for them and use some of our software to have a consistent approach. It's really to mitigate these things. And I'm going to show you later, is don't wait till the end of the year to check your sampling data. You should be looking at it instantaneously because that's really a big factor in mitigating the risk to lawsuits.
So Ryan covered this already to some extent. Congress, in enacting the Clean Water Act, put a citizen suit provision into the Clean Water Act that allows these groups to file claims on behalf of the public. The big benefit is attorney's fees, which I'll talk about, but it's different than if you get a EPA or a state enforcement or a notice of violation. There you can work with them, make improvements. There may or may not be fines associated with it. If these citizen suits go to the extent of contacting you about your problems, there's going to be some some actions that you're going to have to take either through court or out of court, and I'll talk a little bit about that. What they're looking for on those is when you're reporting, if you exceed a effluent standard, which are they tie them back to benchmarks, or the action levels in the general permits, or if you're violating the industrial general permit or municipal permit or whatever you have, that's also a violation of the Clean Water Act. So how they do it is it's public documents, so they go and look. The first thing they're going to look for generally are your self reporting of your monitoring results. So if you're above benchmarks or numeric action limits, as Ryan said, and you've got a history of it, they're going to tie that back to the benchmarks and allege that it's a violation. Once they've done that, they're going to look deeper. So they're going to look at your SWIP, and they're going to look at your the days that you sampled. They're going to look to see that you've done all the inspections that you're supposed to do. There's two things that I think catch their attention. One we've discussed is the sampling results. The other one is canned SWIPs. If they look at your SWIP and it's just an off-the-shelf kind of SWIP and it's not tailored to your site and it's not a program that you're actually implementing, that catches their attention. The next one, and this is the interesting part for me, and from the legal standpoint. So why do they file these suits, and kind of what's in it for them? Obviously, the groups that file these are concerned about the environment, so there's the environmental stewardship. The cynic would say it's to recover attorney's fees, so that provision in the Clean Water Act allows them to, the attorneys to recover fees, and a lot of times, unfortunately, it's the attorneys that are driving the litigation. So they recover fees either through a settlement, it will be part of the settlement provision, or through a court proceeding, and then they turn around, put those fees back into looking for additional people to sue. So they're going to plan those fees, putting that money back into the process to look at additional results, and so the system just kind of feeds itself. So I'll talk a little bit about the process. The first thing you're going to receive is a 60-day notice letter, and what's important about this is to take it serious and act on it. I've had a lot of clients who get the 60-day notice letter and they don't understand what it is and don't take any action on it. So under the Clean Water Act, you have to provide a 60-day notice letter before you file the suit. So when you receive the 60-day notice letter, start taking actions as soon as you can. The other thing with the Clean Water Act is that they have to allege ongoing violations, so it can't be solely past violations. So if there are deficiencies in your BMPs or there are deficiencies in your SWIP, if you fix those during the 60-day time period, you can remove those from a complaint that might get filed later. Unfortunately, they will continue to allege that any sampling violations that you have are going to be ongoing for every storm event that goes on in the future. The other thing that the 60-day law period provides is an opportunity to start talking with the plaintiffs and figuring out what your best strategy is for either litigating or settling, and most of these cases end up settling. You've entered into a settlement agreement or a consent decree, they are going to want to monitor you. So usually these decrees last 2 to 5 years, and there's going to be a reporting that you have to report back to them, both your sample results as they're generated, usually within 15 days or so, and your annual reports. They're going to want to be able to come and inspect your facility, usually on an annual basis. And sometimes the settlement terms will not be consistent with the permit. So they may want lower thresholds than the permits have. They may want additional sampling than the permit has. I had a case I recently settled in Oakland where they wanted to have metals. Metals weren't required to be sampled under the general industrial permit for the SIC code for this manufacturer. The plaintiff's groups wanted metals. We said, no way, we're not going to do metals. And they said, okay, well, if you have a violation, we want you to go straight to exceedance level 2 instead of level 1. And at the time, that seemed fine, but recently we've had an issue with pH, and it hasn't been resolved yet, but that could potentially put them into level 2, even though they have no chemicals on site that would that would indicate that they would have pH issues. So you really need to pay attention to the terms and what happens if you do not comply with the consent decree, or if you miss a deadline. They're usually going to put additional fees in there that they collect as a result of it.
And then Nathan, if you want to talk real quick on the lawsuit prevention, kind of setting things up beforehand, before it gets too late.
Yeah, this just goes back to what you had been saying, and also my original point is that everything is visible, and they want to get people in a position that they have to settle. So they're going to look at everything that's out there. So you want to, when you submit your annual reports or any data that's going to be available for public consumption, you want to look like you're in compliance. So you want to review everything to make sure that happens. And this gets back to some of the stuff that Ryan was talking about. You have to have adequate training of your staff, so as the documents come through the system, they look good. Somebody needs to oversee the process, whether it's a consultant or a EH&S manager on site or somebody at the corporate level. And the SWIP itself is an active document. Another thing that I failed to mention is that when you have an exceedance, the BMP process built into the SWIP is iterative. So don't just say, well, our BMPs were deficient. Acknowledge that they were deficient and continue to improve your BMPs, so that if somebody looks at your sample results and see that there was an issue, and then they take the time to look at your SWIP and see that you've been continually addressing it, that's the way the permit's supposed to work. And if you make it difficult for them to settle a case or to make the allegations, because they don't want to fight, they want this to be an easy process for them, they're going to move on to easier pickings. They're going to move past you. And then the final thing is just, if you get that 60-day notice letter, react right away. You can save yourself a lot of money on the back end by taking steps initially and getting an attorney involved to reach out to them to see what their position is, so you can get a strategy involved for a low-cost settlement that's much more painless than going through full litigation.
Yeah, and to build on Nathan's point about SWIPs being iterative, it's really important, and it's one of the things I was mentioning about inspections and that closing that loop on corrective actions. Looking at your sample data midway through the year, if you're having any problems at all, your SWIP should be changing at least once during the year. Preferably more than just annually, especially depending on your sample results, that you should be going back in and tweaking something in your SWIP or your process and documenting that. And that'll help push back, as Nathan said, against any allegations that you're not paying attention to this or you're not following the iterative process of the permit. Another question, Nathan, about additional pollutants. You talked about how they might push for above and beyond the permit. This viewer is asking, do they have any legal ground to stand on? Can sites deny that? And I think the short answer is everything's up for negotiation. It's kind of outside the permit. But Nathan, if you want to elaborate a little bit on that.
No, that's right. It's contract laws is way, and a lot of people, like clients, have heartburn over this, and for good reason. But contract law is totally separate from any regulatory or legal requirement. I've had good success tying everything back to the permit, and in fact, Ryan we were reviewing a settlement agreement, and Ryan made a bunch of comments on it, saying no, that we need to tie this back to the permit. From an operational standpoint, the client can't be trying to do two different things, but that doesn't stop them from asking. Their initial offer is going to be, they're going to want a lot of stuff. So there's a lot of back and forth to push on it, but there's good argument. The one time that we had it was a manufacturer that didn't have to do zinc, and they're in a real heavy industrial area in in Oakland, and there's no doubt in my mind that it would have been hot, and we just really pushed back on them, and they were trying to say the SIC code should have been different, so we had to do a bunch of research to push back on it. Ultimately, they want it the process as easy as they can make it, so it depends on how hard they want to fight it, but you certainly can push back, but there's no legal reason that they can't ask for it.
Yeah, and pushing back on some of this from an operational perspective is, I really want it, the only way these things get implemented, whether you're in a lawsuit or not, for stormwater, is if it's really simplified for boots on the ground folks. So trying to keep it consistent with the permit, not trying to do a parallel track, is, in my mind, really important for actually getting what the goal of these is to have water quality benefits. Unfortunately, that sometimes is lost in the consent decrees, but to get big impact on water quality, I think simpler is better because then it'll actually get implemented.
To exceed the benchmarks or the numeric action limits. And it's pretty hard to, and well, we would have to litigate it in order to show that you're not, but they'll say based on your history that every rain event going forward, you will continue to violate the permit because you're exceeding the benchmarks, and it's only through their actions that brought you into compliance, so therefore they get they want their attorney's fees. If they've gone to the effort of sending you a 60-day notice letter, they think they've got a claim for future violations, and they're going to want either a settlement or to litigate in order to resolve that issue.
Yeah, and they can go back 5 years on your records. That's why, like in the permits, it talks about a 5-year record retention. They can potentially get all those records and put those in all the sampling data, et cetera.